Welcome, everyone. We are pleased that you have joined us for today's webinar titled The IRS Issues Secure Act Regulations. The webinar will last approximately 15 minutes, and at the end, you will be given an opportunity to receive supporting materials by email. You will also be told how you may email questions related to today's content to the presenter. Today's presenter is Jennifer Lawler. Jennifer joined the Advanced Underwriting team in October 2014. Before joining the team, she spent 6 years working for a tax and estate planning group. While there, she worked extensively on tax return prep, estate planning, and assisting clients with their tax needs. Jennifer will draw on her legal, tax, and life insurance background and practical experience for today's webinar. And here she is.
Thanks, Amber, and thanks for joining us for today's webinar, the IRS Issue Secure Act Updates. We're glad to have you here. Before we get into today's material, I'm going to remind you to join us on November 6th when we'll discuss an overview of probate. As a reminder, we conduct these webinars for free for financial professionals on the first Wednesday of each month. We also post our webinars on our YouTube channel. So if you can't join us, you can find a recording of this webinar and of all of our past webinars on our YouTube channel. Before we get into today's material, we'll take a moment to decide what topic everyone would like to hear about in December. The options for the December webinar are reviewing Form 1099 LTC, life and annuity unanswered questions, and fighting with the IRS. I'm going to launch the poll and give everyone a minute or two to vote on what topic they would like to hear about in December. And the poll should be up now for you to vote. All right, we got about 15 more seconds or so to get in those final votes. All right, it looks like in December we will be discussing life and annuity unanswered questions. Thanks for participating, and hopefully we'll see you all then. With that, we'll go ahead and get into today's materials. By now, we're all familiar with the Secure Act passed in 2019. It brought sweeping changes across the industry. Secure Act updated the RMD age and had some really good benefits for our retirement savers, but it also had some downsides. One of the changes that got the most notice had to do with inherited qualified accounts. Secure Act requires that most accounts be liquidated by the end of the 10th year. Most of us thought that change simply meant that the account had to be empty by year 10. Then the IRS released some proposed regulations that required RMDs under certain circumstances. This, of course, created a lot of uncertainty and confusion. Before we could figure it all out, Secure Act 2.0 was passed. The uncertainty and confusion continued as some of the language was inconsistent and some of the ideas were not fully fleshed out, leaving us with a lot of questions about how they worked. But thankfully, the IRS was very busy in July. On July 18th, they issued final regulations on several parts of the Secure Act and proposed regulations for several parts of Secure Act 2.0. We won't cover all of the 260 pages of the regulations today, but we will hit on some of the highlights. The final regulations clarified the 10-year rule and who must take annual distributions and when. The proposed rules for spousal continuation deadlines were thankfully thrown out. They clarified that all inherited 457B plans are subject to the 10-year rule. It also laid out the rules for those eligible designated beneficiaries and how and when they must prove their status as such. The proposed regulations also offer some potential clarity for some sections of Secure Act 2.0 and even some sections of the Secure Act that have yet to be finalized. As I touched on earlier, the Secure Act changed a lot of things in regard to inherited qualified accounts. It created new classes of beneficiaries, non-eligible designated beneficiaries and eligible designated beneficiaries. Eligible designated beneficiaries are surviving spouses, minor children of the account holder, those who are disabled or chronically ill, and those who are no more than 10 years younger than the account holder. The options for the eligible designated beneficiaries didn't change much. They could still do an ordinary stretch like most of us were used to. Most other individual beneficiaries will fall into the non-eligible designated beneficiary category. These types of beneficiaries are subject to what is commonly called the 10-year rule. When the Secure Act first came out, we all thought that we understood this rule to mean that the account simply had to be liquidated within 10 years of the account holder's death. The original legislation made no mention of RMDs. Most of us were shocked when the IRS stepped in and said that's not exactly the way that they interpreted the rule. So the IRS released proposed regulations and gave the public at large time to comment on those proposals. Because of this, there was a large period of time when we didn't know exactly how the rule worked. The final regulations do settle it. Whether or not the beneficiary has to take RMDs depends on several factors, and we'll get into those in a minute. For those beneficiaries that fall into the eligible designated beneficiary category, not much changed. If they wish to stretch the account, they must begin taking RMDs the year following the death of the account holder. This is true regardless of how old the account holder was or how old the beneficiary was. Typically, the beneficiary in these circumstances uses their age and the single life table to calculate those RMDs. But for most of us, most of the beneficiaries we deal with are surviving children. And so a lot of times, those beneficiaries are going to fall under that 10-year rule. But whether or not they have to take RMDs depends upon the original account holder's status. If the original account holder passed away before reaching their required beginning date for RMDs, the beneficiary does not have to take an annual RMD. Their only requirement is that the account be liquidated by the end of the 10th year. If the original account holder was taking RMDs before death, the beneficiary must take RMDs and then liquidate the remainder of the account by the end of the 10th year. The RMDs will typically be calculated using the beneficiary's age and the single life table. If you've got a beneficiary that inherited after Secure Act or after December 31st, 2019, and they haven't been taking RMDs, but now you know they should have, you can calm that internal panic because the IRS has said that it will not penalize beneficiaries who fall under this rule that failed to take RMDs in 21, 22, 23, and now in 24. Because of all of the uncertainty that was out there around how this rule was going to work. But do know that they will have to take them going forward. So now is a good time to reach out to those clients and try to start helping them plan for those distributions and how they're going to look for them in their tax situation. Surviving spouses have the most options when it comes to inherited accounts. They can choose to be treated as a beneficiary, or they can choose to treat the account as their own. Prior to the Secure Act, a surviving spouse had no deadline on when they could choose to treat an account as their own. But the first set of proposed regulations did put a timeline on that. They said that a surviving spouse had until the later of the end of the year following death or until the end of the year in which the surviving spouse reached RMD age to choose to treat an account as their own. Thankfully, the final regulations did away with that proposal, but it wasn't all good news. The IRS did add some detail on very specific situations. Specifically, they wanted to discourage a surviving spouse from choosing to be treated as a beneficiary subject to the 10-year rule in order to avoid RMDs for the 10-year period, and then at the end or right before the end of their 10-year period, choose to treat the account as their own. The IRS wanted to discourage this. So if you have a client who has chosen to do this and they decide at the end that they want to treat the account as their own, the IRS says that they essentially have to make up the RMDs that they would have taken had they originally chosen to treat the account as their own before they can choose to treat the account as their own. Again, I think this is going to be a very, if we see this, it's going to be very few and far in between. But if you do come across it, it's good to know that the IRS is looking for people in that specific situation with this kind of regulation. I don't know how many of you typically deal with 457B plans, but they are a little bit different than your typical employee-sponsored retirement plan. They are only available to governmental entities and to nonprofit entities. Technically, they're a non-qualified deferred compensation plan, but they act a lot like our typical, qualified retirement plan. But because of this kind of in-between, they do have some different rules. And according to the language of the Secure Act, we were all pretty sure that the inherited governmental 457B plans were subject to the 10-year rule, but it was silent as to nonprofit-sponsored 457B plans. But the final regulations did clarify that they are subject to the 10-year rule. So if any of you do deal with 457B plans regularly, just know that if you come across a nonprofit 457B plan, it is subject to the 10-year rule, like our other inherited qualified accounts. Beneficiaries that are disabled or chronically ill will be considered eligible designated beneficiaries and can do a regular stretch past the 10-year period. Most of us assumed that beneficiaries that are disabled or chronically ill would be able to self-certify that they meet the IRS's standard for disabled or chronically ill individuals. But the final regulations say that for funds that are in a qualified plan, so we're talking your 401k, your 403b, those kinds of plans, your 457 now, self-certification is not an option. So if it's an employer-sponsored plan, self-certification is not an option for those who are disabled or chronically ill. The final regulations say that in order for somebody in this situation to qualify, they must provide proof to the plan administrator of their disability or chronic illness by October 31 of the year following the death of the account holder. This certification must be from a licensed healthcare practitioner that the beneficiary is unable to perform 2 activities of daily living. So again, plan administrators cannot rely on self-certification for this. But IRA custodians, on the other hand, can rely on self-certification. So if you have a client that is very adverse to, having to get a doctor's note essentially to qualify as a eligible designated beneficiary, one way to get around that would be to do a direct transfer into an inherited IRA, and then they can rely on self-certification. So if you ever run into that, know that that might be a hurdle, the certification process. The Secure Act 2.0 did provide a new way to calculate RMDs for our surviving spouses, which was very interesting. We were all excited about it, but we didn't know how it would work. The final regulations do clarify that. Prior to Secure Act, a surviving spouse that chose to treat an account as inherited had to use the single life table to calculate any RMD due from the account. 2.0 introduced a rule allowing the surviving spouse to use the uniform table to calculate the RMD due from the inherited account. This helps the client because the uniform table factors produce a lower RMD. So it's good news. But the caveat to this rule is that it only applies where the RMDs began in 2024 or later. If RMDs began in 2023 or earlier, the surviving spouse is unfortunately stuck with the single life table and that higher RMD calculation. But this is a new way to calculate going forward for surviving spouses who choose to treat an account as inherited. So it's good news. There were several inconsistencies in the original language in Secure Act 2.0 regarding when those born in 1959 would need to begin RMDs. In some places, the language made it look like they would begin at age 73, while in other places, the language made it look like they would begin at age 75. The final regulations made it clear that those born in 1959 will have to begin RMDs in the year that they turn 73. The regulations did provide some leniency for trust beneficiaries, which is good news as well. Generally, a see-through trust can be treated like a non-eligible designated beneficiary. A see-through trust is one that is irrevocable at death, is valid under state law, has identifiable real-life people as its beneficiaries, and where the trustee can provide a copy of the trust by October 31 of the year following death to the custodian of the account. If a trust qualifies as a see-through trust, generally the trustee uses the oldest trust beneficiary to calculate RMDs. But the final regulations provide some flexibility under the right circumstances. Where the final regulations say that where the trust is divided into subtrusts upon the death of the upon the death of the account holder, the trustee can use the beneficiary's age from each subtrust to calculate their RMDs rather than using the oldest beneficiary's age to calculate the RMDs. So this is good news where you have subtrusts for beneficiaries that have large age discrepancies. You can use each individual beneficiary's age to calculate their specific RMD. So that's good news. They're still going to have to be, under most circumstances, they're still going to have to be liquidated, by the end of that 10th year. But, this might provide some flexibility in tax planning with those RMDs. So that is also good news. These regulations included a lot of information and directions, but that doesn't necessarily make dealing with these inherited accounts any easier. We now know that we'll have to collect a lot of information about the original account holder as well as the beneficiary. So it's more important than ever to communicate well with our clients when they have these inherited accounts. We also got a lot of information about how some of these other rules that were a little uncertain worked. So, overall, these final regulations were good news. And they definitely give us some direction on what we need to know going forward. While all of this may seem confusing and uncertain, AUC is here to help with those questions and issues that will continue to come up around Secure Act and Secure Act 2.0. Amber will give you some information about how you may contact us with questions about today's content. We thank you for joining us today, and with that, I will turn it back over to Amber.
Thank you for joining us today. Join us for next month's webinar on November 6th. As a reminder, if you would like to receive supporting materials, feel welcome to email us at asktheexpert@advancedunderwriting.com. You may also email questions related to today's webinar. Check out our YouTube channel to view past webinars. Finally, for more information about the services that Advanced Underwriting Consultants offer, including phone consultation and newsletter licensing, feel welcome to contact us at 615-224-1291. That's 615-224-1291. Thanks again and best wishes for continued success.